Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing K-3 marriage visas. We're specifically discussing this in the context also of adjustment of status. This video is going to be a catch-all video for those who want to understand why is the K-3 not particularly used all that often, and what exactly is the adjustment of status process. So first of all, you need to understand before there was a K-3 visa, there were two types of visas effectively. There were immigrant spouse visas in the CR1 or IR1 category, depending on how long you've been married at the time of entry to the United States, and fiancé visas. These are sort of the two prevailing categories for those who want to bring a loved one to the United States, a significant other. You choose between going down fiancé route or spousal marriage visa route. In the past, going back in the 90s, there was a huge backlog in the immigrant spousal visa processing line. So they created, through the Life Act that President Clinton signed into law, they created the K-3 visa so as to allow the spouses of American citizens to process through the K-1 fiancé visa line because it was moving more quickly. That was later administratively closed because it was determined it was no longer necessary to process those as a practical matter. Occasionally you will see a K-3 visa. The thing to understand, though, about the K-3 and why oftentimes it's kind of the quote-unquote odd man out between the K-1 or the immigrant spouse visa is kind of in a way the worst of both worlds, insofar as it's a marriage visa, but it's a non-immigrant visa. It does not grant resident status upon entry. It also requires adjustment of status, which that process in and of itself is the process of changing over from non-immigrant status to immigrant status or lawful permanent resident status, i.e. green card status in the United States. K-1 fiancés and K-3 spouses are considered non-immigrants until adjustment of status has occurred. That is a process that occurs inside the United States, and depending on the facts in your given case, it may or may not behoove you to seek the K-3. In the vast majority of cases, it's probably not going to be optimal to seek the K-3. For those who feel a bit overwhelmed by all of this, it's probably not a terrible idea to contact a legal professional, gain some insight and guidance into how best to proceed.